Hello everyone, my name is Dian Krishna and I'm here to present my paper on Budapest Convention as a reference in cybercrime governance from 2004 to 2013. The Budapest Convention is the first international treaty on cybercrime that has been ratified by at least 62 countries in 2020. The treaty provides guidance for states to form comprehensive rules and as a framework for international cooperation to fight cybercrime, and the treaty was adopted in 2001. The purpose of the convention is to harmonizing the criminal law related to any crime conducted by cyberspace, and then give powers to national law to investigate any activity and prosecution of crime committed via computer or electronic devices, and as well as to collect digital evidence related to cybercrime, and also to form international cooperation that is fast and effective. This is based on what the Council of Europe stated in their website. The main argument in this paper is that the Budapest Convention becomes a reference in the global cybercrime governance in 2004 to 2013 due to the global changes that influenced the emergence of non-state actors such as international organizations that are working on cybercrime issues, which can be applied at a national level and therefore makes all state actors want to implement these rules. And the Budapest Convention, and in this paper, we also would like to delve more into the Budapest Convention's application in German law. So first, I'm going to talk about the Budapest Convention itself. The Budapest Convention, or formerly known as the Convention on Cybercrime, was drawn up by the Council of Europe with participation of Council of Europe's observer countries. The convention and its explanatory report was adopted at the 109th session of the Committee of Ministers of the Council on 8 December 2001, and it entered into force on 1 July 2004, and in March 2006, the additional protocol came into force. The convention is the first international treaty on crimes committed via the internet and other computer networks, dealing particularly with infringements of copyright, computer-related fraud, child pornography, and violations of network security. It also contains a series of powers and procedures such as the search of computer networks and interception. Its main objective, set out in the preambles, is to pursue a common criminal policy aimed at the protection of society against cybercrime, especially by adopting appropriate legislation and fostering international cooperation. If we take a look at the articles and provisions in the Budapest Convention, we may be able to group or categorize the article into four distinct parts. The first, the Article 2 to Article 13, it contains more of substantive and sanctions related provisions. And from Article 14 to Article 22, it was in a form of sort of like a procedural law. And from Article 23 to Article 55, it dwells more on the nature of international cooperation against cybercrime. And from Article 36 to Article 48, as well, aside from the international cooperation, it also talks about the relating to the impact of the convention, any amendment and repeal of the convention. Well, how did the German national law apply the convention? First of all, Germany joined the convention as its signatory party in 2001 and ratified in 2009. The application could be found mostly in German criminal code that regulates legal aspects as well as the criminal legal aspects of cybercrime, um, as well as any other cyber activity, violation against any cyber law. Other than that, it could also be found on German Copyright Act and also German Regulatory Offenses Act. In this table, we could see that how the Budapest Convention is, how the Budapest Convention articles are applied into the German criminal code, and how in which section, as well as some of them are in the German criminal code and others in the German regulatory offenses. In fighting the cybercrime in German, we can see that the convention in some of its laws that address issues coming from cybercrimes. However, the convention itself only serves as reference that the German laws use, the German laws use the substantive part of the convention as well as provisions that go on the sanctions. It might be noted that not all the provisions are adapted into the national law, but the table shows that there are gaps to be filled in implementing the convention. Therefore, we see that nonetheless, the implementation of the convention is in the German's national law shows that international treaty could increase states' participation in global governance that tackles common issues globally, such as the cybercrime. Thank you very much for your attention.